Hello again. In Module 1, we had introduced the POSH Act and studied some cases to see what amounts to sexual harassment. In this Module 2, I am going to talk about the legislative background of POSH Act. Structure of the Module 2 is background of the POSH Act, salient features of the POSH Act, implementing the POSH Act, legal obligations of the employer under the POSH Act, criticism of the POSH Act. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 is a legislative act in India that seeks to protect women from sexual harassment at their place of work. It was passed by the Lok Sabha on September 3, 2012 and subsequently by Rajya Sabha on February 26, 2013. The bill got President's consent on April 23, 2013. The legislative progress of the Act has been a lengthy one. The bill was first introduced by Women and Child Development Minister Krishna Tirath in 2007. The bill was finally passed by the Rajya Sabha on February 26, 2013. It has come into force and has been published in the Gazette of India on April 23, 2013 as Act number 14 of 2013. This legislation was a follow-up to the landmark judgment of the Supreme Court in the matter of Vishaka versus State of Rajasthan, a rape case involving a social worker in Rajasthan in 1997. The judgment outlined a set of guidelines on sexual harassment at the workplace for prevention and redressal of complaints on sexual harassment of women at workplace. The verdict defined the concept of sexual harassment, laid down duties of employers to deal with it, and stipulated formation of committees to dispose of complaints on sexual harassment at workplace for the first time in India. According to Press Information Bureau of the Government of India, this act will ensure that women are protected against sexual harassment at all the workplaces, be it in public or private. This will contribute to realization of their right to gender equality, life and liberty, and equality in working conditions everywhere. The sense of security at the workplace will improve women's participation in work, resulting in their economic empowerment and inclusive growth. The Act uses a definition of sexual harassment which was laid down by the Supreme Court of India in Vishaka versus State of Rajasthan. It established that actions resulting in violation of one's rights to gender equality and life and liberty are in fact a violation of the victim's fundamental rights under Article 19(1)(g). The case ruling established that sexual harassment violates a woman's right in the workplace and thus not just a matter of personal injury. Salient features of the POSH Act are as follows. The Act proposes a definition of sexual harassment which is as laid down by the Honorable Supreme Court in Vishaka versus State of Rajasthan. Additionally, it recognizes the promise or threat to a woman's employment prospects or creation of hostile work environment as sexual harassment at workplace and expressly seeks to prohibit such acts. The Act provides protection not only to women who are employed but also to any woman who enters the workplace as a client, customer, apprentice and daily wage worker or in ad hoc capacity. Further, the Act seeks to cover workplaces in the unorganized sectors. The Act provides for an effective complaints and redressal mechanism. Under the Act, every employer is required to constitute an internal complaints committee. Since a large number of the establishments in our country have less than 10 workers for whom it may not be feasible to set up an internal complaints committee, the Act provides for setting up of local complaints committee to be constituted by the designated district officer at the district or sub-district level depending upon the need. This twin mechanism would ensure that women in any workplace, irrespective of its size or nature, have access to a redressal mechanism. This LCC will inquire into the complaints of sexual harassment and recommend action to the employer or district officer. Employers who fail to comply with the provisions of the Act will be punished with a fine which may extend up to Rs 50,000. Since there is a possibility that during the pendency of the inquiry, the woman may be subject to threat and aggression, she has been given the option to seek interim relief in the form of transfer, either of her own or the respondent, or seek leave from work. The complaints committee are required to complete the inquiry within 90 days, and a period of 60 days has been given to the employer district officer for implementation of the recommendations of the committee. The Act provides for safeguards in the case of false or malicious complaints of sexual harassment. However, mere inabilities to substantiate the complaint or provide inadequate proof would not make the complainant liable for punishment. The rules on the subject, namely the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Rules 2013, have been notified in the Gazette of Government of India on December 9, 2013 for smooth implementation of the POSH Act. Implementation of the POSH Act will be the responsibility of central government in case of its own undertakings, state government in respect of every workplace established, owned, controlled or wholly or substantially financed by it, as well as of private sector establishments falling within their territory. Besides, the state and central government will oversee implementation, as the Act casts a duty on the employers to include a report on the number of cases filed and disposed of in their annual report. Organizations which do not prepare annual reports would forward this information to the district officer. Through the implementation mechanism, every employer has the primary duty to implement the provisions of law within his establishment, while the state and central government have been made responsible for overseeing and ensuring overall implementation of the law. The government will also be responsible for maintaining data on the implementation of the law. In this manner, the Act will create an elaborate system of reporting and checks and balances which will result in effective implementation of the law. The Act mandates the employers to provide a safe working environment devoid of sexual harassment to their women employees. Employers have to take preventive and remedial measures to make the work environment safe for women, failing which they will be punished. The employers are mandated to formulate an effective anti-harassment policy which prohibits sexual harassment as part of institution service regulations so as to provide a healthy workplace environment. The officer responsible for implementing the law is the head of the institution or any other officer which is assigned the responsibility by any specific order. Employers' duties under Section 19 of POSH Act to provide a safe working environment at the workplace, including safety for the persons coming into contact at the workplace, to display at any conspicuous place in the workplace the penal consequences of sexual harassment, sanitize the employees with the provision of the Act by organizing workshops and awareness programs and orientation programs for the member of the internal committee, facilitate the internal committee or the local committee for dealing with the complaints and conducting inquiry, to provide assistance in securing attendance of respondent and witness before the committee, to make available such information to the internal committee as may be required with regard to complaint, to provide assistance to the aggrieved woman, cause to initiate action against the perpetrator where the perpetrator is not an employee in the workplace at which the incident took place, monitor timely submission of reports by the internal committee. Additional duties of an employer under Section 22 of POSH Act are: the employer of any organization is under a statutory obligation to prepare an annual report and include in that report the total number of cases, complaints of sexual harassment filed with him and how they have been disposed of under the scheme of the Act. POSH Act has often been criticized on following grounds. If a woman is found guilty of making a false complaint or giving false evidence, she could be prosecuted, which has raised concern about women being even more afraid of reporting offences. Women activists feel that such provisions will deter a woman to come forward and complain. Concerns are often raised about the role of the employer in sexual harassment cases. There is no stipulated liability for employers in case of employee to employee harassment. It has also been felt provisions related to address grievances in a timely manner at the workplace is problematic because of potentially uncooperative employees. Furthermore, the law requires a third party NGO to be involved, which could make employers less comfortable in reporting grievances due to confidentiality concerns. It is also feared that provisions may get misused by disgruntled women employees. Ultimately, success of law depends upon its implementation. Passing of acts, rules is a major step. However, whether it would help or not would depend upon its effective implementation and confidence that it generates in the women. This brings us to the end of the module. Thank you for your attention. Feel free to play this video as many times as you wish. You may also wish to download the same. Just to remind students again, you get complete free and downloadable course material and IALM copyrighted ebook upon finishing of your course and submission of your assignment. You may click on Move to Next Unit at the bottom of this page. This will take you to multiple choice questions. The MCQs will be directly or indirectly related to the information contained in the present module. If you still have any questions or clarifications, feel free to write to us at registrar@ialm.academy. If it's a weekday, we will respond to you on the same day itself. As always, IALM wishes you good luck for your very bright professional career ahead. Thank you.